Father, with all respect, just to remind your lordship, the medical report
Lordship,
was called.
Yeah.
Wow.
He's suffering from hypothyroidism minor or with generalized anxiety disorder.
Kidney is also impacted. I know. Kidney
February, right?
ক্যান্সার এটা তো ফেব্রুয়ারি করলে মার্চ এপ্রিল তবে একেবারে হবে এইটা মানে স্টোন
According to the jail doctor, at present is clinically stable minor and his vital parameters are within normal limits and he's in oral medications. That's a fun. No. Yeah, I think it is.
Thank you. Yes, madam. I control, but I remember that he is a thyroid patient, madam, and diagnosis with hypoglycemia with hypoglycemia. And plus above that on 17.2, his reveals right renal calcula with bilateral renal, that's kidney stone, madam. So he needs.
Please do the report. Don't receive 17 February.
Yes, madam. Which one, madam? 22?
That recent last month's report. June month, June 25th of June.
Yes, madam. To 22/6/24, he was referred to the medicine department of GMCA for his fever, cold with malaise. He got admitted on the same day at the medicine department of GMCA. He was diagnosed
No,
as.
read the discharge certificate.
Oh,
This is of 25th of June.
yes, madam. I'll read.
He was admitted on 22nd of June.
Yes. Investigation, all BM closed. Fibromyalgia, hypoglycemia, general anxiety disorder, hyperkalemia, correlated. Superintendent of Police in program given
Statement
physical.
conservative,
Yes, ma'am. Conservative, man.
then see the result.
Madam. Conservative, yes.
See the result. That's a teacher certificate, right?
Yes, madam.
You improved. Improved.
Result shows improved. On the back page, there are medication.
And the next page reveals, my lord, is calculia, my lord.
That's of 17th of February, February.
Yes, madam, but he's still carrying that stone, my lord. That's,
Last report
yes,
is of 25th of June, that is the discharge certificate.
no, my lord, that is one aspect.
Updated.
Yes. Other page,
And
my
the
lord,
report is already there. The doctor has given the report.
he is carrying, he is having kidney stone, my lord. That's troubling him, my lord. That is still there, my lord. Until and unless it
There
is
will
not.
be a ground for his release.
No, my lord, that's one way looking into it, my lord. Now, that is one way, my lord. Shall I read that?
So we have seen that he is in custody since
Yes, ma'am.
2019, right?
Yes, my lord.
Yes, Mr. Das, tell us whether he needs to be continued in the custody or he can be considered for bail. If so, well and good. If not, why?
Length of detention incarceration.
That we have to.
Lordship, your lordship permits me a leave. sir.
Yes, please, ma'am. Thank you. Thank you.
Report of what you
It is apparent that earlier, considering his land in custody, the court did not allow his bail application, right?
Right, my lord.
So he is in custody.
Yes, my lord. He is in custody for more than, my lord, 5 years, 2 months.
27th of May 2019.
The last paragraph of the opinion, madam. At present, he is clinically stable.
No, that's fine. Everything, we are not on that.
Medical aid is,
We are,
medical.
medically, we have nothing to do at this moment. Earlier, the petition was filed last year. That's why we wanted to have an updated medical report of the petition or the appellant. So, he is before us. You have also seen
Alright.
he has improved in his medical health. Kidney stones are there. Now, considering that he is in custody.
For the last
since
5 years, 2 months,
27th
my
of
lord.
May
That
2019,
that
more
will,
than
I
5
will,
years plus, right?
I will second that.
And it appears that out of
Wait, I have to improve, right?
172 witnesses, prosecution witnesses named in the search sheet, only 22 prosecution witnesses have been examined. More than 150 witnesses are yet to be acted. So considering that aspect,
কোন তারিখ হলো?
kindly tell us whether this detinue can be considered for bail or
Madam,
not.
madam,
If
Right.
not, why?
only that part, madam.
Right.
No, only that part. No. To be covered,
Oh,
madam.
sorry,
No,
আপনার
he's
তো-
working over.
Madam.
Only few rounds, medical, then the blank of detention,
Madam.
that's all. And this number of witnesses here are yet to be examined.
Madam. Yes, one part, madam, one part, his involvement in the case. How crucially he is involved in the case. That is one part. The other part that your lordship has come out. That is true. That is one fact that he has served over more than 5 years and all, and there that and whether court can access the power, discretionary power to grant bail. That was.
If we are not supposed to exercise the discretionary power, why we should not? That one.
Yeah. No, my lord, just shortly, my lord, this accused
Yes. Yes.
of Sanjeev Taluka, my lord,
Discuss things are like this, so let's. Push to the. এখনো কর্মকর্তা নেই, কোনো কথাই নেই। মোটে এটাকে পচাই দিই। তেনেকুৱা কি কিয় লয় তেতিয়াহ'লে যদি নাহে কৈ দিলে হৈ যায়। One third.
Well, he is involved with the organization, that Alpha, and will come later on involved in the case. The first part,
Yes,
the first part your lordship will see that he was in the Myanmar jungle. We have given in our affidavit, my lord, the photograph with accused number 1, who is involved in this present case. The Papu Coast, no, Papu Coast. Now,
yes, yes.
I'll come in details to that.
Please, sure.
Seven, eight. Eight. Yes, it is. इंटरव्यू 24 में लिख दिया हम लोग अपने में लिख दिया
Please proceed.
Correct.
It is only on your submission we will consider at this stage. Mr. Das,
My lord,
please come to page number 78
of
Our page,
of the
BM.
appeal memo of appeal.
Memo. of it.
memo of
That is your charge sheet.
Part of it, sir.
78. Paragraph.
Yes, please come to 16.5.
Follow up.
Wait, 16.5, yes, my lord.
Kindly read.
As part of objective of Alpha, the top leaders of Alpha 1, including Procedural and Onoda Assam, Onoda Dohotia, and other leaders of Alpha, conspired to carry out terrorist act in the state of Assam. In pursuance of this conspiracy, several Alpha 1 cadres, including hardcore Alpha, accused Papu Kos,
Bokolia.
Bokolial, Bijoy Assam, and V. Rajni, accused number 1, was dispatched from Alpha 1 camp in Myanmar by Alpha 1,
I came.
Alpha I, leaders to carry out the terrorist act in the state of Assam in the month of April 2019. Papu Kos Bokel, Vijay Assam, and B. Rajni, accused number 1, was instructed to take help of other co-accused, namely Janavi Shekia, accused number 2, Panmoy Rajguru, accused number 3, Indramon Bora, accused number 5, and Sanjeev Talukar, accused number 7, and proceed to Guwahati for carrying out the terrorist. 16.6.
Yes.
On reaching Guwahati, Papu Kos Bokel was instructed to select target for terrorist attack, and in his task, he took the help of Sanjeev Talukdar, accused number 7, in scouting for possible target in Guwahati city. Pranay Rajguru, accused number 3, and Janavi Sakia, accused number 2, was instructed by Alpha 1 leaders to provide all necessary assistance and logistic support to Papu Kos Bokel, accused number 1, in executing the terrorist act. In assisting Papu Kos Bokel, Janavi Sakia, accused number 2, provided shelter to Papu Kos Bokel at hardship rented accommodation
Hello,
at
Gollo.
Namghar Pat, Panchabari, Guwahati, Assam. Pranay Rajguru, accused number 3, was also residing with Janavi Sakia, accused number 2, at the same rented house. This rented house of Janavi Sakia, accused number, was further utilized by accused person as the base of their operation and their plan conspiracies for carrying out the terrorist act and finalized in this rented house of Janavi Sakia. Seymour Locker, accused number 4, later joined Papu Kos, accused number 1, Janavi Sakia, accused number 2, and Pranay Rajguru, accused number 8, at this rented house as part of aforementioned conspiracy, where the accused person, namely Pranay Rajguru, and we finalized the plan to commit terrorist act in Guwahati. For the purpose, they stored a lot of incriminating materials, articles used for making IED, 9mm pistol, live ammunition, magazine, etc. in the rented house of Janavi Sakia. Pursuant to this deep-rooted conspiracy, as per direction of Paresh Barua and also some accused number 1, Seymour Locker, accused number 4, Pranay Rajguru, accused number 3, and Janavi Sakia assembled at Zoo Road, Tinali on 15/5/2019 and organized a meeting for short filing. In the said meeting, Pranay Rajguru directed Papu Kos, accused number 1, and Seymour Locker to carry out the reconnaissance of the target area, that is Naka patrolling party of police SSB near Central Mall, Guwahati, who is corroborated with the tower location of accused person. The instruction and conspiracies to commit terrorist act was passed through messenger service of Facebook and Gmail. On 15/5/19, Papu Kos, accused number 1, and Seymour Locker did a thorough reconnaissance of the target of their planned terrorist attack near Central Mall, Guwahati, and at about 14:30 hours, All four accused persons assembled again at the same rented house of Janavi Saikia, which is also covered with the tower location and of used mobile phone of accused person. On 15/5/19, a police patrolling party of Pitanagar Police Station, along with SSB personnel, was conducting checking from 14 hours onward at Rajipura Road, near Center of Guwahati, under Kitanagar Police Station at around 1940 hours. Simo Locker, 804, was riding the motorcycle and Papu Kos Bokalial, AK-1 was riding pillion on Simo Locker motorcycle. The motorcycle was proceeding from Juro Tinali towards Ganeshguri, and when the motorcycle reached near Central Mall Guwahati, Papu Kos Bokalial lobbed a grenade aiming at the security personnel who were conducting Naka checking near Central Mall Guwahati. The grenade lobbed by AK-1 exploded, which led to the injuries of 12 persons, grievously injuring some of them. The injured persons were immediately shifted by the uninjured security personnel to various hospitals for immediate medical treatment. Immediately after the grenade attack, a requisition was given to the fingerprint so and so, so and so. Assam, who arrived at the spot and conducted thorough search of the area where some splinters, sharpness were recovered. Subsequently, on 16/5,
Now, not
2019.
quite further. So this
Mala.
is your search sheet, and in the search sheet, you have only identified the accused number 7, the present appellant. That the accused number 1 was instructed to take the help of this accused number 7 to identify
Yes. Place.
the place
Select
where
the
to
places.
place the targets
But,
to wherefore. Now, during the entire conspiracy, in the search sheet, there is no mention of the accused number 7.
Yeah.
Right.
Yes, yes, true.
Will you able to show any material against accused number 7 from this search sheet?
Madam, accused number one, the present accused father, accused number 7.
Yes, Mr. Das, please carry
Madam,
on.
his role,
Yes.
Sanjay told Malad, appellant, his role was bringing accused number 1 and helping him here at Guwahati and to meet the other conspirator, that is accused number two and three. There, he didn't go, there is no evidence that he participated in the execution of the.
No, that is not the case. As per the report, it is very clear. Come to page number 78, para 16.6.
16.6.
78. What, 78 point?
78.
Page 78, para 16.6.
78.
এই তলত একদম তলত
Yeah. On reaching Guwahati, accused number one was instructed to select target for terrorist attack and his so and so, and took help of Sanjeev Talukdar in scouting the possible target. But no,
So
He
here
has
is the
not
possible targets in the Guwahati city.
But-
Now, what was the target? As per the
mother,
Facebook, then WhatsApp, the messenger mail.
mother.
he never went together.
So there was target was determined. And other accused persons were found in the vicinity of that particular target from the
Mother,
towers, right?
mother.
So mobile towers practically. And then in the para 16.7, 16.8, 16.9, 16.10, there is no involvement of this accused number 7 in
No,
either way.
true.
Right.
So that
Only
is, that
up
is
to this level, we could find that accused number 7, the accused number 1 took the help of accused number 7 only to identify the targets.
not only that, mother. He
16.6.
no, he facilitated because there was a conspiracy
So was
to come to
so
Guwahati.
was the materials. No, nothing like that. The accused number 1 was sent by the organization,
Yeah,
right?
the chief.
And was instructed to take the help of other accused persons.
He never went, they never went together.
This particular search sheet clearly mentioned to the help of other accused person and to proceed to Guwahati to carry out terrorist act.
Mother.
And the accused number 1 took the help of the accused number 7 only to identify the targets.
Sorry,
Remaining paragraphs in
Mother.
this search sheet
mother.
regarding the conspiracy,
So,
regarding the preparation of
Yes.
all these
mother,
requirement for the terrorist act, there's no mention of the accused number 7.
mother, target means they had a, because the organization,
See,
Time- mother,
targets,
just-
target was fixed.
mother,
Central
time to time, mother, the organization, they remain silent and they want to just to come to the news so that they want to say that.
Basically,
Yeah,
Mr.
like-
Das, you have
So that is,
show, that is
that
why
is
I'm
where-
asking you. Show us from this particular search sheet about the involvement of this appellant. Furthermore, this is your document. That is why I'm asking you, show us any other material of involvement of the accused number 7, the present appellant,
But-
in other involvement in this particular committing the crime.
mother,
Like you have mentioned at 16.7, 16.8 about the other accused persons,
that,
where there is no mention of accused number 7. Similarly, show us the involvement of accused number 7
No.
in this search sheet, accepting para
true,
16.6.
mother, that he is not involved in that throwing, that is true. But he was in the conspiracy
Which conspiracy?
that such and
Because in
such,
the conspiracy, it was in the house of one particular lady in a rented house where the other
they
accused
knew,
persons were
yeah,
named.
they knew,
Even in there,
Yeah.
the name of the petitioner, name of the appellant was not mentioned.
that will depend from the, this, mobile data, mother,
Please see,
mobile data.
show us. That is why we want to know from you.
That will-
Just search it where it is there.
Yeah. Mobile data.
We're not supposed to read the entire search it, right? Show us, show us, show us. Come to page number 97.
Yes, your lordship will find
Mobile
mobile data. You also will find at page 104, my lord.
Come to page 96.
97, 97.
Come to page number 96, see the liquidations.
Yeah, yeah. 97, yeah, 97, 97
Phone
is,
call chart.
yes.
Ekon, ekon. Ekon, ekon.
No, 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 I get it. The connectivity source of accused owner as group, Janabi Sekia,
Sanjeev is there.
Sanjeev Talagra, yes. Sanjeev Talagra and Paras Haspa. In the accused location. The tower location, BTS mobile number operated by accused owner Rajguru, Janabi Sekia, Sinha Lokma, Papakos, Landry established the fact that the said accused persons were physically present at the Panjabi near Masjid Rented House meeting place 0 That is one call from Sanjeev Shaikia, Sanjeev Lakar. Sanjeev, sorry, Sanjeev Talbar. Then you
Now come to page number 104.
104. The role of improvement of Sanjeev Talukdar emerged during the course of intersection of as one of the overground worker of Internet so and so. The accused is an active supporter of so and so, and he is maintaining link with cadres of Alpha One, who are carrying out subversive and anti-national activities, including terrorist acts. He has provided logistic support to cadre of Alpha One by providing transport to Alpha One together and has actively participated in the recognition of the target of Alpha One cadre. He is also actively associated with the conspiracy to commit terrorist act in pursuit of goal of Alpha One with other activities. The photograph of Sanjeev Talukdar A1 was extracted from the mobile phone of accused Papukos Vokel. Accused number 1 established that Sanjeev Talukdar is associated with the accused Papukos, accused number 1 in operational activities. The photograph of Sanjeev Talukdar was clicked with accused Papukos and other Alpha 1 in the jungle, which indicates that he was roaming with the members of Alpha. In other photographs, he was also in the uniform of Alpha with the firearms in standing position, aiming at something through the said firearms, which strongly indicate that he has got training with Alpha 1 in handling of arms. The statement of protected witness X in the form of 161, 164 CRPC established that the association of accused Sanjeev Talukdar 7 with Papapu 1. During further further course of investigation, it came to light that the accused Sanjeev Talukdar, accused number 7, was using Facebook so and so, communicate with other members of the analysis of CDR of mobile used by accused Sanjay Talukdar confirmed the conspiracy. On the revelation made by accused so and so of the mobile number so and so, he had two mobile number used by Sanjay Talukdar was collected from the concerned service provider and studied. It was found that the accused was in telephonic contact with members of Alpha. During analysis CDR of mobile number so and so, it has revealed that accused Sanjeev Talukdar using said mobile number was in telephonic contact with accused Papu Kos so and so and Rajguru. Customer application so and so received the concerned service provider established the accused Sanjeev Talukdar Guwahati University is actually service provider of that. Connectivity search software. Now, in this evidence, you also will find that he had three calls. Three calls he made. That is, my lord, accused number, he contacted accused number one with three calls from 25/4/19 to 27/4/19.
25/7.
Sorry, madam. Sanjeev Talkar was using mobile number so and so and two number and in contact with accused number one Papu Ghosh on 27/5/18 to 26/5/19. That is just after the blast with mobile number so and so 9468. That is 19468 last number. And accused number three, that is Pranay Rajguru from 27/5/18 to 26/5/19. Thus, immediately after the incident happened on 15/5/19. So immediately after the incident, with mobile number, number so and so 53724. Sanjay Talukdar contacted accused number one from 8/8/18 to 16/5/19.
It's a prior.
16/5/19. So immediately after the blast.
No, my lord, not immediately. It's prior to the blast.
Can
25/4
15/5 is the blast.
Just a minute, just a minute.
analysis.
16/5 is the incident.
Which para you are reading, Mr. Das?
My lord.
Which
Boba
para you are reading? Para. Page 100,
তোমার হেইটা CDR খন আছে।
তো আপনি লেখান না
No, no,
document
CDR খন
বড়
আছে, CDR খন-
that's your preparation.
No, CDR
We are showing it from your document. CDR analysis.
the whole
Can you tell us the page number?
Document number 83, my lord, at para 5, my lord.
Document number 83, page.
Oh, yes. No, document number 83 is will be probably with the trial court or which in.
That is not before us.
My lord, we have got it. This is the prosecution document. Oh,
Just a minute.
This is the part of the charge sheet, my lord. 207 supply, yes, my lord, down below, my lord. Thamba, on 25.
এটা কি হবে? হ্যাঁ, ঠিক আছে।
তার আগত
তা- all the documents were called for murder and this
Yet to be examined, Kolkata examined. Examine Kolkata. चलो कारो मान हमारे इसे बिल्कुल ना हमें ज्यादा बिल्कुल नहीं हो এখন তুমি বনাই লোৱা তুমি ট্ৰাই কৰা খুব বনাই ক'ব নোৱাৰা
Very good. They can put it. Yes. With this category. If we take it up, we can have it. We can like or a key evidence is not for the very good. In order to compare the order, about everybody. Thank you. Happy to proceed.
Mr. Das,
Well-
term of punishment under section 13 of the Unlawful Prevention Act. How much? What is the maximum period?
Seven years
No,
maximum, which may extend to 7 years.
18.
13 or 18. 13 is not in the, 18 is punishment for conspiracy, which is not less than 5 years.
Less than 5 years. What
But
about
may extend
38?
to 38 not exceeding 10
38
years
and
or with fine or with both.
39?
Offense relating support giving to them, not exceeding 10 years or fined or with both.
Now, 120B,
120B is death or life
Then-
imprisonment or RI for term of 2 years or upward.
121,
That is death or life imprisonment and fine, madam.
121A,
Life imprisonment or imprisonment which may extend to 10 years and fine. Now, my lord, this is the charge sheeted section, my lord. The charge was framed under 4 sections, my lord. 121A, 18 UAP, 38 UAP, and 39 UAP, my lord.
18, 39, 38 and 39.
he has only complied with the 18,
Yes.
right? Now remains on the 38, 39. Maximum 10 years. He is already in custody for more than 5 years. 121A, it's life or 10 years.
My lord, 121A is life, my lord.
Life,
Life or imprisonment which may extend to 10 years and fine. My lord.
is life.
That is the problem.
Tell us, why should you keep him in custody?
Still
Well,
125.
coming, let's compare. Let me compare. There is one.
What we have noticed is that from the CDR report, that from the CDR, not CDR report, CDR is that the accused number one in his in one of the phone number called him on 25th of April and 27th of April.
Right.
In the other phone, the accused number one called him on 27th of April on 4 occasions. That means on 27th of April, the accused number one called the appellant here, accused number 7, on 5 occasions during the day from 11:35 to afternoon 16:30. On 30th of April 2019, the accused number one called the appellant in his other phone in between 11:15 hours to at night 21:30 hours, 9:30 from morning 11:15 and on 8 occasions.
Yeah.
So all this way,
Prior.
on 14 occasions, the accused number one called upon the appellant up to from 15th of from 25th of April to 38th of April. Incident occurred on 15th of
15, 5.
15, 5. 15, 5.
that means the last call was on 30th of April 2019 at 21:28 hours. On 30th of April, 15 days prior to the incident. Is there any other material? Oh, because
This is how is a statement of protected witness, my lord.
Please, you can continue. Because আমি খুব করি সব কথা কৈ কেনে ওলাব পাৰিলে মই খালি সেই এইটো জাজমেণ্ট দিম আমাৰ যে অবজাৰভেশ্যন আছিল আমাৰ হাইকোর্টের রিপোর্ট করতে অবজারভেশন সেটা হবো তাই তো বলবো মই কি কম কৈ আছে কম কথা আৰু চিন্তাই কৰি আছে সিহঁততকৈ মই বেটাৰ কণ্টিনিউ নকৰিবি আৰু বিয়া আছে আজিও কৰিম আৰু কিন্তু আকৌ আমি ৰিপিট কৰা নাই কণ্টিনিউ নকৰিব কিন্তু আকৌ দিনে কণ্টিনিউ নকৰে অলৰেডি গোটেই ৰাজনীতি বিয়াই বেয়া হ'ব ঠিক আছে গাঁৱতে মই কৰিলে ভাবি মই পইচা লৈ যাব পাৰিম মই কৈছো তিনি খালি ফল্ডিং নকৰিব এটা প্লাষ্টিকের বেগুন যদি হয় তাহলে তোমার সাইজ আমি শূন্য ফোল্ডিং হয়ে যাবে
Yes, Mr. Jones.
Now, no, your lordship will find that this is his role, that is bringing Equator one to Guwahati, providing him some kind of he had Equator one
Secondly,
to come to Guwahati, and thereafter, my lord, after requisition, he placed the core group, that is equation number 2, 3, 4, and 5, where they were holding up in Panchabari, my lord.
Not Sanjeev.
Panchabari, yes, it was there.
Sanjeev was not there.
So he did not go for execution of the plan, my lord. The lopping of drainer, etc. and all, he was not in that part.
yes,
I did not buy intentionally avoid the control. I never make
Now the law, my lord, the laws will find
yes,
your laws will find 43D5 of the UAP Act, where you also find that if upon looking into case study, you also will find that there is a prima facie case. Then restriction of bail is restricted. 43D5. Notwithstanding anything contained in the code, no person accused of an offense punishable under chapter 4 and 6 of the act shall, if in custody, be released on bail or on his own bond, unless the public officer has been given an opportunity of being heard on the application of such bail. Provided that such accused shall not be released on bail on a, or on his own bond, if the court, on perusal of the case diary or the report made under section 173 of the code, is of the opinion that there are reasonable ground for believing that the accusation against such person is probable. The restriction on granting of bail specified in section 5 is in addition to the restriction under the code or any other law for the time imposed on granting bail.
yes.
Now, this in Najib case, the court has granted bail on the ground of delay, as your lordship has pointed out. Now, this again, my lord, in Gurvinder Singh case, my lord, reported in case number to Kimatanchla.
Kindly give us the citations.
We got a great case, online to case, and like over the there was an online case, Gurinder Singh case, my lord, where, I'll just take it.
Give us the citation. Do you have the citation?
It's a reportable problem, madam.
Not
Online case.
reportable. We'll take it out.
Contact to read to
That's
What
what
else
I'm
additional
saying.
scheme should
I
we do?
won't
We
give it
have
to-
the online.
No, that one.
We have the.
This is
online.
online, minor. We have
No.
taken it out.
There's an online hearing, 2000.
24 INSC 92.
Give the party's name.
Gurvinder Singh
Gurvinder Singh
versus State of Punjab.
State of Punjab and Assam.
Criminal appeal
G
number
or M? GURM or B?
GURWI. Man, we are leaving a copy for your lordship, man.
Do you have a copy?
Yes, man.
Do you have a copy or no?
Yes, yes, I have one. We'll share it, man. No issue.
Now, this case, Matar, while
Yes.
uh, discussing Matar, K. Najib case was placed
Hmm.
and put into service, Matar, and at paragraph 32, Matar, K. Najib case was paragraph 32.
Hmm.
The appellant counsel has relied upon the case of K. Najib to
Page
back
34.
his contention,
Page. Para.
the page 21.
Page 20.
21. The page number is down below.
Down below, man.
Down below.
Yes, para 32.
Para number.
Para number 32. 32.
Please.
The appellant counsel has relied upon the case of K. Najib Supra to back his contention that appellant has been in jail for the last 5 years, which is contrary to law laid down in the said case. While this argument may appear compelling at first glance, it lacks depth and substance. In K. Najib case, this court was confronted with circumstances wherein, except the respondent accused, other accused had already undergone trial and were sentenced to imprisonment for of not exceeding 8 years. Therefore, the court's decision to consider bail was grounded in the anticipation of the impending sentence that the respondent accused might face upon conviction, and since the respondent accused had already served portion of the maximum imprisonment of more than 5 years, this court took it as a factor influencing its assessment of gun bail. Further, in K. Najib case, the trial of the respondent accused was severe from the other co-accused, owing to his absconding, and he was traced back in 2015 and was being separately tried thereafter. And I had filed a long list of witnesses that were left to be examined with the reference to the said accused. Therefore, this court was of the view of unlikelihood of completion of trial in near future. However, in the present case, the trial already underway and 22 witnesses, including the protected witness, have been examined. As already discussed, the material available on record indicates the involvement of the appellant in furtherance of the terrorist activities backed by members of banned terrorist organization involving excess of large quantum of money to different channels which need to be dissipated, and therefore, in such scenario, if the accused appellant is released on bail, there is likelihood that he will influence the key witnesses of the case, which might hamper the process of justice. Therefore, mere delay in trial pertaining to grave offences or as one involved in the instant case cannot be used as a ground for grant of bail. Hence, the aforesaid argument on behalf of the appellant cannot be accepted.
This is your case. That although he is
No.
in 5 years in custody, that bail should not be granted because.
Yeah.
prima facie his involvement is section.
But
My lord, just I'll point out.
Come back to you.
Sure, sure, sure.
So that is why one.
No, there is a
Mr. Das first. We have tried other way.
Yes.
Because your arguments we know.
No,
and
actually,
this
the
is-
law point is that, my lord, that Najib was 3 judges judgment, and this is 2 judge judgment. First,
No, they have differentiated.
Yes, sir.
Najib's case,
Differentiate.
because in the Najib's case was tried
Absolutely, sir.
separately. And the other accused were already tried. and
right,
they were punished.
absconding accused, my lord,
And
right.
that was as punishment was given for 8 years. And
Again-
in this case, in the Najib's case, what had happened? Since you was tried separately as you was absconding and later on,
Right,
these 2 judges found in that case is that since he is already in custody for 5 years.
5 years.
So, and the punishment was of 8 years. The trial did not complete.
Completed.
So he was granted bail. So the
What-
case of Najib's case is different than the case
There,
of
there.
Surinder Singh. That's what they have.
Now, just one more line I would like to add, my lord. After of these 2 judgments, my lord, another judgment has come in the form of Soma.
We'll come back to
So,
you.
Miss-
You tell us, you tell us.
That, in that case,
We know.
both the cases were taken.
We discussed. Yes, you know. Come back to you later.
now, whatever, my lord, here, this is a legal position that K. Najib case cannot be just taken out. bluntly.
No, you want to say that
Can't-
as the present appellant is in
Madam.
custody for more than 5 years,
Ah.
that cannot be a ground to release him on bail.
Madam, that is,
Because of his involvement,
Exactly.
prima facie
Exactly.
has been
so
found.
each case has to be, madam, this case has been tried separately, and if a lordship is satisfied because of these factors, that is a different thing. The law is this, that cannot be accepted bluntly. That is what I want to say. This case has to be tried because, as I have said, that his role is not here in the execution. That is showing of lobbying of home, etc. His case was from
Bringing him from one place to
me
another.
also that place he came here, he that he placed him with a court room. That is. Now another factor that you also will appreciate, madam. I'll just now this man, madam, that is attracting section 38 and 39 of UAP Act. Now, membership.
Unlawful behavior.
Yeah, now, this man, Malon, he was with accused of 1 prior to the incident in the jungle. And we have filed our affidavit, but he was with those guns, etc. and also those, I would not say. Now, your laws will just appreciate one thing, that one cannot enter an organization that is organization based, because he will be either he will be taken to task as that you are an informal or so unless he had some rapport, some relation, some contact, or he is a member, then only he can. So this accused, he had freely gone there because he had a good relation with them. We do not know what is the relation, but it shows that a deep relation with Israel. So
No, one thing you could see that in your search you have specifically mentioned that in the mobile of the accused number 1, photographs of this particular appellant. together with him,
yes.
And also in the jungle,
Yeah,
having
this-
all these things.
Yes,
are
this
mentioned.
photograph, it was analyzed by the scientific Malon, and you have found that it is not a mob. That is it.
It's not mock, it's original. mock.
Now, what I want to say, why I'm bringing this thing. Supposing today, tomorrow, your lordship decides that to give him the liberty of bail. That man is of his character, that he is associated with the organization. Then what will happen to the fate of the other witnesses who will, that your lordship will take? Because here we have got prima facie evidence that he is with the character. So, he being out, and what will be the case of the other witnesses who is
If I
will
threaten
be-
witness, my bail will be
that
taken.
your lordship will take. I'm not saying anything more than that, your lordship, because we have found that his antecedent is. That's all.
Yes.
My lord.
Mr. Kamal.
My lord, before I start with the facts of the case, my lord, I'd like to show, my lord, because earlier my bail petition was rejected with a certain direction, my lord. If your lordship will kindly, it starts from, my lord, page 112.
Seen that?
Yes, no, just pointing it out so that I can take
Where is the
a
direction?
drive from there, my lord. 112, it starts, my lord. And what was the direction, my lord? everything was considered, my lord, but unfortunately. Page 162, para 91 and 92.
That's right.
I just read for our convenience, my
Right,
lord,
right.
so that I can further enhance my argument, my lord. In the present case, we are of the prima facie view that the appellant, that is Sanjeev, my lord, does not appears to be a hardcore under trial, and his role is marginal in the bomb blast incident on 15/5/2019. And as such, his bail can be considered even before completing 5 years of detention. If he has completed 4 years of detention, at that time it was 4 years. If there is no likelihood of the trial being completed in the near future. So till now, out of the 177, 22 has been examined. Now, my lord, the punch para, my lord. Accordingly, while dismissing his bail application, we grant liberty to the appellant Sanjeev Talukdar to approach this court again on completion of 4 years. So, my lord, here I'd just like to point it out legally, my lord, that I cannot directly approach this honorable court, though the High Court has given a direction. Because of the fact, my lord, that only appeal can be filed as an impugn order of rejection of the bail order by the trial court. So I have to go to the trial court first. After getting rejected, then I came up before your lordship, my lord. So I did not come up directly, my lord. So again, on completion of 4 years, and as on date today, I have completed 5 years, 2 months, my lord. If in the meantime, there is no substantial progress in the trial and there is no possible of conducting the trial in near future for seeking release of the bail in the light of the observation made in K.M. Nazir. Accordingly, my last para, my 94. Accordingly, criminal appeal 136 is allowed. Criminal appeal 67 of 20 is however dismissed with liberty to the appellant Sanjeev Talukdar to approach this court again as observed earlier. So now I am before your lordship on that. All the judgments I have given, the honorable earlier bench was pleased to accept my argument, but the period was after not 4 years or so. That's why your lordship has given me a direction to that. So in the meantime, my lord, 3 co-accused has also been released on bail. 3 more co-accused.
What was,
Yes, my lord. One is one Amrit Ballabh Goswami.
that was by this court only. First, he was released.
Yes, my lord. Then Prakash Rajkumar
That was also on this particular, when
This
this bail
particular.
prayer of the appellant
and
was
Indra
rejected.
Mohan Bora, my lord, who was the harborer who gave shelter and make available everything to him, my lord. Indra Bora, my lord. I'll give the number and I'll give the judgment, my lord. So these 3 accused has direct connection with all these persons, my lord. No, number what I could get. But I'll give the accused number, my lord.
Pranay Raskuru, he has been given bail.
Yes, my lord.
Then
Indra Mohan is A5, my lord. Pranay Rasguru is A3, my lord. Pranay, I'm sorry, my lord. The Pranay is the deadly, my lord. Prakash Rajguru, sorry, Prakash Rajguru. A8. And Amrit Ballabh is A6. And I am A7 before your lordship, my lord.
Pranay Rasguru given,
Yes, my lord.
then Indra Mohan Bora given,
Yes. A5,
then
A5, A6,
Amrit
Amrit Ballabh Goswami. And A8, my lord. Prakash Rajkumar, L.I. Chow Ning Thi Lao.
Prakash Rajkot also given.
Yes, my lord. Prakash Rajkumar, A8, my lord. A5, A6, and A8, my lord. And we are A7 in between, my lord.
A3 given,
No, my lord.
Pranay Rasguru not given.
No. That's it was because same confusing name, my lord. So I took it.
So A5,
Six,
A6, A8.
A8. I'm A7.
A7.
So this is how I am before your lordship now seeking freeze bill. though Honorable High Court on the earlier occasion, my lord, granted me that can come directly after 4 years. By this time, passage of time, I have completed 5 years and 2 months, my lord. And the most important fact is that till then, my lord, till today, my lord, only 24 witnesses has been examined out of the 177. And all the other accused persons who have been released on bail are equally facing trial as on today without any default, my lord. So for the information provided to me, none has absconded or none has done anything as such, my lord.
So as
And
on
I-
24.
Yes, 24 as on the last date. On third, no, 7 May, the third May, my lord. More than 150 witnesses are still to be examined, my lord. And till now, my lord, with all respect, as I've been instructed, and I have also appeared in the trial court, my lord, and I have seen, my lord, that of the 24, my lord, not a single witness has directly implicated me, save and except one FSL, my lord, expert, who has identified the photographic part, my lord. That must show, my lord. Nothing beyond that from the 24 witnesses has come. And if your lordship, the PP has taken your lordship to those protected witness, if that protected witness is looked into, my lord, it goes in favor of me, my lord. On a plain reading of the protected witness, my lord, acts, my lord, I have asked, I have not met him, I have not taken him to any place as alleged in the charge sheet that I have to be given a task to identify the places that I have not done it. He came, the person Alpha came by posing it as a student, my lord. And at that time was running a coaching classes for the people, my lord. So I only said that one boy will be coming, so you go and kindly help him. That must show. That cannot be termed as a terrorist activity, or neither I have asked to show anybody anything, my lord.
Okay. Yes, okay.
My lord, I'll just like to show his social antecedent, my lord. That I, being an UTP, my lord, I pursued my education, my lord, from the jail, my lord. And I was placed successfully, my lord, highly successfully, my lord. Then I qualified for being taking the counseling, my lord, of PhD, my lord. If your lordship will kindly look into page 199, my lord.
160.
In the meantime, my lord, this is 10/8/23. Of course, I could not pursue it because of this case. I was not allowed to leave jail premises, my lord, because they need regular students. So just pointing it out, my lord, Department of Botany, Guwahati University PhD program, GURET 23 counseling schedule, total 14 seats, my lord. The following application are shortlisted for counseling on 10/8/23. The counseling process will commence at 10 a.m. The applicant must come with the following documents, my lord. So these are the persons who have been selected, and in the next page, I am placed at page 19, my lord. So for this category A, unreserved seats are concerned, my lord. I was placed in 19, my lord, and had I been there, probably I would have been selected, my lord. But I could not participate it, so that way I have also been deprived of my education and future, my lord. And I was having a brilliant academic record, and I came out with flying colors in my studies, and I was a topper from the securing first class first position in the Master of Arts in Sociology. Your Lordship will find it at page 169. It starts from 167, my lord. Your Lordship, those Krishnakanta Hendrik State Open University has certified it, issued a certificate showing that I am the university topper certificate. Sanjeev Talukdar has been awarded the topper certificate for securing the first class first position in the matter for degree of Master of Arts in Sociology in 2022. And I was a good debater, my lord, even in all competition, I have come out with flying colors, my lord. So I was preparing for my IFS, my lord, that is Indian Forest Service. But because of this case, I could not further pursue it, my lord. So unfortunately, his career was cut in the nip of the bud, my lord. So right now he wants to revive himself and settle in life, my lord. So a chance may be given to him also, my lord, so that he can pursue his studies and regain his confidence, my lord, and be a good citizen also, my lord. So these are the social aspect. Now coming back, if your lordship takes me on the legal aspect.
Yes, please.
Well, in the legal aspect, I'll submit, my lord. All the judgment has been already referred, my lord. In the earlier judgment, everything has been taken care. Thereafter, certain three judgments has come up, my lord. That is, my lord, one is I don't look into it. My lord, one is Javed Ghulam Sheikh has recently come up, my lord.
Yeah, what?
We have downloaded it, my lord. আপনি তো কিমান পেজ আছে কোনখন দিছে আপুনি জাগৰখন দি দিলে Para number 7 and 9, probably my mark copy has gone to your lordship, my lord. Trace one I can. Yes, my lord, for your lordship convenience. Now, this judgment is Javed Ghulam Sheikh, my lord, versus State of Maharashtra. Two judges, my lord, pronounced on July 3rd, my lord. I'd like to take your lordship to para 7, my lord. Having heard the learned counsel appearing for the parties and having gone through the material record, we are inclined to exercise our discretion in favor of the appellant, herein keeping in mind the following aspect. The appellant is in jail as an under trial prisoner for the past 4 years. I am 5 years. Till this date, the trial has not been able to even proceed to frame charge. Here, charge has been framed and evidence has started, and 24 PWs has been examined out of 177. As pointed out by the counsel appearing for the state as well as near, the prosecutor intend to examine not less than 80 witnesses. So they have not stated in anything that they will curtail or not. But assuming it is 177 as of now. Then having regard to the aforesaid, we wonder by what period of time the crime will ultimately conclude. However serious a crime may be, an accused has a right to speedy trial as enshrined under the Constitution of India. Over a period of time, the trial court and the high court have forgotten a very well settled principle of law that bail is not to be withheld as a punishment.
Okay.
Then, my lord, para 11, my lord, Gurbakh Singh Sibba, I needless say, my lord, your lordship is aware of that landmark judgment. The same principle has been reiterated para 11 by this court in Gurbakh Singh Sibba versus State of Punjab in 1982 SCC that the object of the bail is to secure the attendance of the accused at the trial. That the proper test to be applied in the solution of question whether bail should be granted or refused is whether it is probable that the party will appear to take his trial, and that is undisputable that bail is not to be withheld as a punishment. So I have already completed more or less of the half of the sentence, save and except one section which is life, my lord. Otherwise, I could have.
1982 SCC, kindly give the page number.
Yes, my lord. This Gurbakh Singh Sibba is 1982 SCC 565. 1980, volume 2, SCC 565.
Right. Anything else?
My lord, just two more paras I'll read. My lord, then we'll come to para 21. We are convinced that the manner in which the prosecuting agency as well as the court have proceeded, the right of the accused to have a speedy trial could be said to have been infringed, thereby violating Article 21 of the Constitution of India. In view of the aforesaid, the appeal succeeded is hereby allowed. The impugned order passed by the Honorable High Court is set aside. So this is one leg of submission, my lord. And in para 16, my lord, Najib's case was also taken into consideration. In paragraph 16, my lord, in the said judgment, Najib's case was taken into consideration. If your lordship looked into it, it will be a three-bench judge of this court in Union of India versus K. Najib, reported in 2021 3 SCC 713, had an occasion to consider the long incorporation and at the same time the effect of section 43D5 of the UAP Act and observed as under. It is thus clear to us that the presence of statutory restriction like 43D5 of the UAP per se does not oust the ability of the Constitutional Court to grant bail on the ground of violation of Part 3 of the Constitution. Indeed, both the restriction under the statute as well as the power accessible under the constitutional jurisdiction can be well harmonized. Whereas at the commencement of the proceeding, the court are expected to appreciate the legislative policy against grant of bail, but the rigors of such provisions will melt down where there is no likelihood of trying being completed with a reasonable time and the period of incorporation already undergone has exceeded a substantial part of the prescribed sentence. So I have also done substantial part of the prescribed sentence. Such an approach would safeguard against the possibility of provisions like 43D5 of the UAP being used as the sole metric for denial of bail or for the wholesale breach of constitutional right of the speedy trial. So in my case also it's covering that aspect, my lord. Now that in between the judgment has come in the form of Gurbakh Singh. Gurbinder Singh, my lord. So in Gurbinder Singh, thereafter came one judgment, Somi Sen, my lord, versus State of Maharashtra. No, Soma Sen, no. Somi Sen versus State of Maharashtra. There, my lord, it was distinguished by saying that K. Najib was a three-judge larger bench and this Gurbinder was two-judge bench, my lord. And the ratio of that case, my lord, has always to be there, my lord. So, if your lordship permit me, my lord, I have only downloaded version, my lord. Right now, if you permit me, I'll read it from here, my lord.
Just a minute. Sharma.
Criminal appeal number sombo dite na Soma. Commission में.
Yes, see online.
ইমান কাগজ আছে লিখি থাক। কাগজ এখন ইমান দি দিছে। সেইটো পুৰা লিখি দিয়ে ক'ব ভাল বেডটো কেতিয়া মাৰ্চ আৰু এইটো আছিল গুৰবিন্দ হা অবশ্যই অবশ্যই ঠিক আছে দাদা এই নাই আজি এইফালৰ এই অবজারভেশন Kion নাই rising out. নহয় সেইটো আছে এইটো দিম নহয় সেইটো পোৱা নাছিলো মই তাতে নাই 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 ঠিক আছে ওইটা লেখেন সেইটো কোনটো চাইট হয় নাই আজিকালি এইবিলাক নহলে বৰ দিগদাৰ এতিয়া আপোনালোকৰ অফিচৰ মেনেজাৰ কৰিব মুখত জেলৰ পৰা থাকি বৰ দিগদাৰী কি হ'ব আল্টিমেটলি জানে বনাই থৈ হাঁহটো হাঁহ নাচো বাকী আমি কৰিব Come on, man. So last leg of submission will be this, my lord. It has come up in the live law, my lord. The Supreme Court on April 5 in the Soma Pal Sen case made a crucial observation that the apex court finding in the Gurbinder Singh versus State of Punjab case will not disturb the ratio arrived in the landmark case of Union of India versus K.A. Nazib. It may be recalled that K.A. Nazib's case was pronounced by a three-judge bench compromising of justice such and such. The case was marked as a relief for the accused under the Unlawful Activities Act. Therein, the court held that the Constitutional Court would grant bail to individual accused under UAP, notwithstanding the statutory embargo of grant of bail created by Section 43(d)(5) of the UAP. This was done to protect the accused's right to speedy trial guaranteed under the Constitution, under Article 21 of the Constitution. So what your lordship said is that K. Nazib's case was segregated regarding distinguished by pointing out that Nazib's trial was separated from the rest of the accused, my lord. Your lordship rightly pointed out. And that's Soma. My lord, this Soma Kanti Sen, my lord.
Yes, versus State of Maharashtra.
Maharashtra disposed of on 5/4/2024
That's right.
is connected with criminal appeal number 2595.
Which para you are saying?
My lord, para 37 of that, my lord. Huh?
That is a case, my lord, where even the charges were not framed, my lord.
No,
And
that was the earlier
Somakan.
one. This one is
Somakan.
charges frame
Somakan.
trial was on.
Somakan.
Bhim Koregaon case. This last one. সেইটো মই দিছিলো যিটো জাভেদ গুলাম নবী ফটোটো ওলাই তুলি লওক that I am reading from para 37. Shall I read, man?
Yes, please.
In the case of K. Nazib Union of India, reported as such, a three-judge bench of this court, of which one of us was on such party, has held that a constitutional court is not strictly bound by the prohibitive provision of grant of bail in the 1967 Act and can exercise its constitutional jurisdiction to release an accused on bail who has been incarcerated for a long period of time relying on Article 21 of the Constitution of India. The decision was sought to be distinguished by Mr. Natraz on the facts appearing for Nia, my lord. On facts relying on the judgment of this court in the case of Gurvinder Singh versus State of Punjab, 2024 INSC 92. In this judgment, it has been held that the appellant counsel has relied upon the case of K.N. Najib Supra to back its contention that the appellant has been in jail for the last 5 years, which is contrary to the law laid down in the said case. While this argument may appear compelling at the first glance, it lacks depth and 22 substances. In K. Najib's case, this court was confronted with a circumstance wherein, except the respondent accused, other co-accused has already undergone trial and were sentenced to imprisonment of not exceeding 8 years. Therefore, the court's decision to consider bail was grounded in anticipation of the imprisonment sentence that the respondent accused might face upon conviction. And since the respondent accused has already served portion of the maximum imprisonment, that is more than 5 years, this court took it as a factor influencing its assessment to grant bail. Further, in K. Najib's case, the trial of the respondent accused was served from the other accused owing to his absconding, and he was traced back in 2015 and was being separately tried thereafter. And the NIA has filed a long list of witnesses that were left to be examined with reference to the said accused. Therefore, this court was of the view of unlikelihood of completion of the trial in the near future. However, in the present case, the trial is already underway and 22 witnesses, including the protected witness, have been examined as already discussed. The material available on record indicates the involvement of the appellant in furtherance of the terrorist activity backed by members of the banned terrorist organization, involving exchange of large quantum of money through different channels, which needs to be deciphered. And therefore, in such a scenario, if the appellant is released on bail, there is every likelihood that he will influence the key witness of the case, which may hamper the process of justice. Therefore, mere delay in trial pertaining to grave offences as one involved in the instant case cannot be used as a ground to grant bail. Hence, the aforesaid argument on behalf of the appellant cannot be accepted. That was in Gurvinder Singh, my lord. But lastly, in this case also, Somapal Sen's case, my lord, the Honorable Supreme Court allowed the bail in spite of that. Para 42.
Just tell us one thing, Mr.
My,
Kumar.
sure, my lord.
Why section 43D5 will not be applicable in the present case?
Yes, my lord, because the twin condition is that, my lord, that prima facie whether I am guilty or not. Till now, whatever material has case, because now your lordship will also distinguish one big feature, my lord. Here we are not in investigation stage now. It is in trial stage. Trial has commenced. Till now, what is the material brought before the court? Till now, the material has to be also looked into, my lord. Because that was in investigation stage, they may write many a thing. Just like a fairy tale, which I have also shown it in Amrit Vallabh's case, your lordship will see in that judgment, that criminal trials are not fairy tale, that anybody can write anything like a storybook, my lord. That observation is Amrit Vallabh's case. That's why Amrit Vallabh Goswami was granted bail by this honorable court. Because in the charge sheet, they write many things. But when it comes to the court during the trial, that is the substantive evidence that has not been brought into the record. Till now, my lord. Not a single whisper. Save and except that one FSL expert was examined who has identified certain photographs. But mere identifying the said photograph also doesn't connect me, my lord. That is what is happening in the trial, my lord. And the other main feature is that, my lord, all the co-accused has been released. They are still attending court and facing their trial. So will I do it, my lord? So these are the twin condition I am fulfilling it, my lord. As of now, I am not guilty of the offense, my lord. Because guilty of the offense, your lordship will see, basically, my lord, with all respect, I'll submit, legislature has used this line, my lord. But my contrary submission, the whole legislative is itself at fault, my lord. Because a person will be held guilty or not guilty only at the conclusion of the trial. How can a person be held guilty at the beginning of the trial itself, my lord? But since it is a legislative provision, my lord, we will have to abide by it, my lord. Because this UAP is not that stringent than the NDPS Act also, my lord. Because Only the restriction is the twin condition, my lord, that I must give notice to the public prosecutor and give an opportunity of being heard and may not be released on bail on perusal of the case diary or the report under 173 of the officer prima facie true, my lord. Not guilty also. In the NDPS case, guilty is the line, my lord. Here only it should be prima facie true, my lord. It's more liberal. That is what I'm trying to distinguish it, my lord. The language incorporated here, my lord, and the language incorporated in NDPS Act, my lord. In NDPS Act, your lordship will see
More
not
stringent.
guilty. But here it is prima facie true. So on taking into the evidence of the protected witnesses at his face value, even if unrebuted, my lord, it goes to show that I have not taken any way part with Papu Coach, my lord. Because I avoided him, suspecting something that he may not be a student. So I avoided him and I asked somebody to help him if one can. That is X is saying, my lord, protected witness X. So that's why the
Do you have
allegation,
a,
my lord.
printout copy of the Summa and
Yes, I haven't taken out the copy. It's a big one, but today
we
morning.
are reading.
Yes,
This is before us. No, we just wanted to hear Mr. Das in this regard. Mr. Das, in this particular case of Soumya Kumari Sen versus state of Maharashtra,
Later, Mars.
here, just like you, as you have mentioned, uh, at para 38, the learned prosecutor have placed before the court. That's why we wanted you to go through that one and to make your submission. Because if you go to, because para 37 relates to Najib's case, there their lordships have clarified that at para 38 and 39 was the argument on behalf of the prosecutor. Thereafter, the court came to the conclusion. They have said that it will be, even it is 43D5, as you have mentioned,
Yes.
that bill cannot be contained at the prima facie parametric. That is an issue where the Honorable Apex Court, the lordship have said that Article 21 is to apply. You go through, we'll consider in the second half in that case. You go through this judgment or not. এই কানুন.com আছে তারপর print out করে দিই। Print out relative. We call তোমার কানুন You go through, if you have a printout, show it to Mr. Das.
I'll share it with him.
Uh,
Because it's of something 82 pages. Today morning I got it, I did not know.
You can show it to, at a camp failure. Preferably you keep at this moment. Go to paragraph 37, 38. Okay. 37 onward. Print full.
Gurvinder to किसी और
That's okay.
Gurvinder to किसी
Print out print.
काफी नहीं होता
Para 37 to 43 print out.
वहाँ काफी नहीं
Indian business is going on like a month. Paragraph 37.
ये तो पैरा की मैंने देख ना लेता no it will be 16 ये तो Gurvinder no
Please take your seat. Just a minute.
তো এতিয়া উঠালে চাইলো কি এই বাক্সটো আছে কি নাই। কিমান কোনটো নাই মই ডেটটো বিচাৰিছো নহ'লে আৰু
এই সমাকান্তি থাকতে হয়। হয়। কিন্তু তোমাৰতো হেৰিয়ে মানে মই জানো এইটো তোমাৰ মানে ব্যক্তিগত
অ এই পেৰাগ্ৰাফ কেইটা দি
Is it correct?
পেৰাগ্ৰাফ কেইটা
নাথাকে প্ৰমাণ আছে।
বুজি পাইছো ৰিলিভেন্ট খিনি দিছে। ইয়াৰ পৰা ৰিলিভেন্ট খিনি আৰম্ভ এইটোৱে হয়
এইটো সমাকান্তি চেন নহয় জানো?
সমকান্তি
নাথাকে মই এইটো বহুত ডিপলি চাইছো মই তাকেই হয়
তোক নহয় নহয় সমকান্তি চেনো চাৰ্জ হৈছে এইটোত
নাই তাই
অ
জবত মাতো যে এনেই প্ৰথম এটা কি হৈছে কথা মই
হেৰি হেৰি দিছে ওকে সমকান্তি এভিডেন্স ষ্টেজ কিমান হৈছে মই নাজানো মই চোৱা নাই আৰু একদম বাম্বো প্ৰথম পেৰাগ্ৰাফ after filing of the transcript is the document
Both side marane? 29 bit. Almost 6 years. Mr. Das, the court has given you the entire judgment. Matter relates to 43D5. You go through the entire judgment
No,
and the charge sheet was filed under
6 years.
1967 Act. So 43D5 was involved, and also go through it and let us know in the second half. In this particular judgment, considering this particular judgment, whether you can consider bail of the person.
Madam, this Somakati and Marat, I have, I do not know, this is what,
Go through it, go through it.
I have gone through it. Earlier, Madam, I have gone through it. Where your logic will find in the facts of the case that she was kept under trial for 6 years. She fought in the trial court as well as in the high court. Then the matter came to high court. Oh, Supreme Court, Madam. And Supreme Court has looked into the matter.
No, because in that particular case, the appellant at every stage preferred bail and her bail application was rejected. The subsequent, the last occasion when the matter was transferred, the investigation was given to the NIA and NIA filed the supplementary charge sheet. Thereafter, she again filed bail application.
Madam.
Initially, that was objected by the prosecutor.
Madam.
And then the High Court rejected it. Of course, there was another issue in that this particular judgment.
It was not
Was
remanded.
The
No, it was not. It was not.
public prosecutor also raised the issue of maintainability.
Yeah.
So in first part of the judgment, the Honorable Apex
Right.
Court considered the maintainability of that particular
Right.
bit. And then, of course, as discussed entirely under 43D5, whether it will be
43,
applicable.
okay.
And in that circumstances, whether under the 43D5, that particular convict could have been continued to be in bail. Thereafter, deciding under Article 21, that is why we have asked you the relevant paragraphs are from, because 37 is the Nazim's case that has been discussed. Thereafter, 38, 39, the submission of the prosecutor is because of the 43D5. Thereafter, the Honorable Apex Court has considered granting bail. Facts are like this because he was in
Yeah.
jail for some.
Those are
period.
the facts, yeah.
But thing is this, considering, because even if it is more than 5 years or 6 years, if there are materials on a 43D5,
Right.
bail cannot be granted.
Granted.
And that is why in this particular judgment, the Honorable Apex was considered about the 43D5. So for that purpose, we have asked you to go through it and come back at 2 and let us know.
Madam.
Ever signed up that? বর্ণালী তো অরিজিনাল তো দিক যেতে থাকে রেড দিতে ওটা ঠিক
You have the entire judgment now with you. You can go through it.
Oh,
and
yes,
let
yes.
us-
Madam.
We'll come back at 2.
Yes, my only issue, my lord, at 2, I may not be here, he will be here.
Yes, I
but-
think your part is over.
More or
Only
less.
on the reply to be made,
Yes.
whether this case, because
Yes.
the issue here is.
Before I think, then I'll just point out one more thing, my lord. Just one more point out, would like to, so that all points are covered, my lord. Because if we come to the para devoted to Sanjeev, my lord, at page 104, my lord, if a lordship will kindly have a turn, my lord.
Page 104.
Yes, my lord, it starts,
Hold on.
and 105 is the connectivity of the accused in the last part, my lord. Only one page at the most can be said has been devoted against me. Regarding all the accused person, others 5 to 7 pages has been devoted.
104 you're talking about?
Yes, my lord. I'm referring to page 104, para 17.25.
Yes.
That is the only para devoted against me in
Yes.
one page, my lord,
Yes, yes.
strictly speaking. Now, if your lordship will see the connectivity chart.
Hmm.
Connectivity chart of accused Sanjeev Talukdar, A7 with
That is in
Pronomoy
page,
Rajguru and Papu
105.
Kokulia is only with 2%, and in total 14 calls and 2 connection, not like the other person who were having hundreds and many calls, my lord. So only with 2 other accused person there were connection, my lord. So only I was having 1 call with Pranay Rajguru and 13 calls with Papu Koch. Let us assume it to be correct. But it is not coming out that whether he has come as a student, my lord, and Omrit Bollab, my lord, who was granted bail, and Prakash Raj, who was granted bail, they have 101 calls each, my lord. I have analysis from their CDR analysis, my lord, and it shows that Amrit Vallabh had made 101 calls in total with all other co-accused, and Sanjeev Talukdar has made only 4 calls, my lord.
We will not go to that extent.
No, I'm just showing it, my lord. The prima facie, it is not true that what they are alleging it, my lord. I'm just pointing it out. My load is minimal, my lord. Just because I happen to have some photographs, that is why I have been solicited in this case, presuming that I am a member of Alpha, my lord. And I have met the
No, what they
opportunity.
could show is that
Yes.
your photograph with other
Yes,
things
that is
was
the
found
only
in
impeding impedance
number one.
standing.
That
That is the
also
only hindrance, my
is
lord.
in the jungle,
Yes, my lord.
right?
But that is taken from some other photo. When it was taken, whether it is connected with this particular incident or not, that is also not sure, my lord. When is this photo dated, my lord? What is the source of the photo? All this will come, of course, in trial. We have already examined the FSL, my lord. But if I'm
But the
really,
FSL report reveals that it is not,
Prima facie.
it is the original.
yes, my lord, we have cross-examined him. The lady, my lord, who came. I have cross-examined him, so I am aware, my lord, we have demolished the cross, my lord. That this is not the way. That will, of course, will be taken care in the trial, my lord. Right now, the period of incarceration, my lord, is the most important thing, my lord. Length of detention, and especially on the observation made by the
Whether
honorable
length
High
of
Court.
detention will come under 43D5.
Yes, my lord. One aspect, constitutional court can look into, my lord. One aspect, my lord. Apart from that restriction, my lord, whether prima facie true or not. PD trial is a fundamental right that is in consonance with the other judgments, my lord. But otherwise, there is no such material directly connecting me with this case, my lord.
You will look into it.
Yes, my lord,
Let
definitely.
Mr. Das clarify.
Well, I'll just finish it, my lord. That's all, my lord. And especially 3% has been already granted bail by
That
the
we have
honorable
taken
court.
note of.
And the other, the observation made by the honorable High Court while rejecting my bail application.
Okay.
Vis-a-vis all those.
So come back at 2, Mr.
Madam,
Das.
yes, madam. So I may be excused, my lord. Much obliged. Oh, Banda.
Met please also, man. No. Generally, when we place a judgment, my lord, we try to fortify our points and assist the court. But the only thing is that your lordship will see whether the situation of that particular case do apply in this case or not. Now, we at least we have understood the role played by this accused somehow, matter up not to the end point, matter up to the starting point. Now, the decision of Somokandi and which your lordship may kindly turn to page 41 Paragraph 41, page 26. Page 26. Once we find that section 43D5 of 1967 Act would not be applicable in the case of the appellant, we shall have to examine the case of the appellant in relation to the accusation against her under section 13 of the so and so of the case, which we have narrated earlier. We have already indicated that she is a lady of advanced age, so and so, my lord, that we indicated. Now, stopping here, my lord. What the court indicated, my lord, once we find that section restriction, that is 43D is not applicable in this case, then we proceeded to another. Here, your lordship will come to why the court indicated that paragraph 33 at page 22. Page 22. Now, may I just point out, my lord, the accused here, he is such under section 38 also, 38, 39, and 18, and 121. Now, paragraph 33, section 38 of the 1967 Act carries the heading of title,
You are reading.
offense relating to membership.
Last you are reading para 33.
Para 33, para 33 at page 22.
At page 22.
22.
That's not para 33. Okay,
Has your lordship got it?
okay, okay. Yes,
Section 38 of the 1967 Act carries the heading or title, offense relating to membership of terrorist organization. As you have already observed, a terrorist act would have to be construed having regard to the meaning assigned to in section 15 thereof. We have given our interpretation to this provision earlier. Terrorist organization, as employed in section 2M, in our opinion, is not a mere nomenclature, and this expression would mean an organization that carries or indulges in terrorist act as defined in section 15. The term terrorist organization. Now, here you also will kindly just pause a minute. Now, this organization, Alpha, is listed as terrorist organization in the schedule of the Act.
so read section 15 of the 1967 Act.
1967. You also will find.
What is the terrorist act is defined
Yes.
here.
In the schedule, I'm carrying a book, Manoj, at page 35. At serial 11.
11.
Serial 11.
UAPM.
UAP Act. Has your lordship got it?
Which schedule?
The schedule that I'm
First
reading.
schedule, second schedule.
Yes, but that is first schedule, Manoj. Terrorist organization. At serial 11, United Liberation Front
Yes,
of Assam.
fine, okay.
Now,
What do you want to show from it?
no, what I want to show, Manoj. Now,
Please take your.
this organization
It's a
is
band organization.
a band organization,
terrorist
is a terrorist organization. Now, section para 33, it says that it has to commit a terrorist act. Now we come back to our case, Manoj. There was a terrorist act on 15/5/19, throwing of bomb, that is defined in section 15 of the Act. Section 15 of UAP Act, you also will find that throwing of bomb, etc. and all things that comes under terrorism. So this embraces this. section 38 embraces that there was a terrorist act. So section 38 will come in play. Whereas in Somakati Sen, there was no terrorist act.
So, Mr. Da, for the purpose of section 38, ingredients specified in the section 15 of the 1967
Yeah.
Act or UAP Act.
Yeah.
Has to be there. Will you be able to show any such materials from your search sheet?
In my
Because the
search-
court has to be prima facie satisfied. There is the existence of
Terrorist
section 15, the ingredients of section 15, right? Prima facie satisfied
Madam,
because
yeah.
we at these stage are not supposed to go to the evidence.
No, we are not.
Only
No,
have to
but
see
what
prima facie
I am
satisfied
just
for
only
making 43D5.
while
Exactly.
arguing my case, Mala, I'm
So-
just okay.
So that is why I want to know from you. That is why from the beginning we are saying, in the morning also we are saying it that. So was the material to be satisfied, the prima facie satisfied that yes, for his continuation in the custody or for the implication of 43D5,
Mala, yeah,
there are material.
I understand.
So now there has to be, since section 18 has
Yeah.
ingredients of section 15, whether the search sheet contains
No.
any such prima facie
Right,
material.
right. No, I understand that. Now, when this Somakati, one Somakati Sen was placed before it, I was trying to analyze that. That case is on a different footing, where there is no terrorist act at all.
Where the lordships found that particular lady
Hmm.
doesn't come under the purview of section 15.
Hmm.
So the provision of section 18 of the UAP Act is not
Right,
applicable.
yes.
So in that circumstances,
Madam,
43D5 will not come.
madam,
And in that circumstance, in violation of
Madam.
Article 21,
madam,
since already she was there for more than 6 years,
but
the
no.
honorable apex was considered for her bail.
So that is what I was saying, that Somakati Sen is in a different footing than our case. Our case, madam, yes, the only factor that remains your lordship, as I have said, I have to, that is before your lordship, madam. Yes, there are 24, some witness has been examined till now, and there is a delay. And that is for your lordship, because what I say, yes, there is a restriction for treaty, but this constitutional court has power, that in spite of the restriction has power. That I won't say, my lord. But the thing, when we are facing the judgment, this judgment, whether it will come to assist the appellant, I would say that no. Independently of this judgment, 43D5, independent of your lordship has power. That is a different aspect of law. Am I clear, my lord? So, but the thing is that your lordship has to see the whole situation, whether granting the liberty of bail, whether these accused will destroy the case. As I have already said, it's only at a part of paper. This man is not like other accused who are granted bail. But his background is little different, although many other certificate has been placed. I wouldn't say anything on that matter. But what the case is a case matter. And what the evidence that has come, that is before lordship. By this factor, because by this man, if he comes up, whether we'll have a fair trial in that case, that is possible. That is what. So this Somakati and Malot, I would humbly say, Malot, that with all this paragraph, Malot, that stands on different footing, Malot. Malot, the medical certificate is here, Malot. Possibly your lordship would may require it because that was called for.
So that's why he has improved.
Malot, that was called for. Maybe that may.
My lord, in this regards, may I be allowed to say? My lord, he has been behind the bar since last 5 years, 2 months, and he has been suffering from kidney stone, whereas he has got multiple operations of kidney stones since last 3 to 4 times, but it has not yet recovered. It is occurring subsequently by the time the kidney stone is not yet over. And for this, his heart palpitation is getting higher. Since last day before yesterday also, he was supposed to get admitted, whereas at the end of the day, he was sent back to jail.
How did you get it?
So it was the information passed from the family members.
It was not placed before the court by the learned public prosecutor. It was forwarded to the public prosecutor. How did you get it? No
Sir-
copy was forwarded to you.
No copy was forwarded me. It was the information given by the jail authority to the family members.
There was no such direction from the court. How did you get? Who provided to you?
My lord, from the family members of the accused person.
Where from the family person get it? Because there is no such direction here, or the copy was not forwarded to the accused person or to anyone. This is a copy including the envelope. How did you get it?
My lord, this was the information.
Call Miss Bernali here. Take your seat. Yes, Mr. Das, you can go ahead. You can go ahead. So your only ground is that there was an excess of the petitioner, of the appellant,
My lord.
with this
But-
appellant, with the people from the PAN organization. Prior to the incident, apparently there was contact
My lord, yeah.
with the appellant from the member of the
My lord, my lord.
PAN organization. Had many phone calls. The protected witness
Yeah.
indicated it is the appellant who asked that witness
My lord,
that he will be contacted by
my lord.
the accused one. Of course, at that point of
Right.
time, the accused one was not known to
Right.
that particular witness. And only after arrest, the photograph been
My
shown,
lord,
and it was in the social media.
Right.
The protected witness came to know that the appellant was connected, because it is the appellant who indicated the accused number one
my lord.
to that
And
protected.
yeah, they have, he was sent to core group, the core group, accused number 2, 3, 4. My,
That connection,
Yeah.
prima facie is not there. But all these things are from, yes, there were phone calls from accused number one. And also there was a call from one of the
yeah,
accused in this
Right.
case. And then, search it as a whole doesn't indicate much about the appellant after 38th of
38.
April.
Right.
Nor it indicated anything that the appellant was in the vicinity of the particular place
Yeah, yeah.
where they had planned to execute their action. And then, anything else, because this Soma condition matter is in a different way
Oh, yeah.
compared to,
But
yes. To that extent, right? Anything
these are
else?
the prima facie materials, my lord. That,
And also you have differentiated the Najib's case,
Right.
because Najib's case related to a different person altogether. because facts of the case is different.
But
And we have pointed out one thing here, that the cases where bail granted, those cases, Surinder Singh or Noah Kantis, and that other case played by the appellant side. In fact, it was more than 4 years.
hold it. Yeah.
There was the charges were not framed.
Yeah.
So the appellant was simply languishing in the jail custody.
Yeah.
So that's why proposed considerably the honorable apex court or the constitutional court considerably. Mr. Das, public prosecutor, Mr. Das. On the last occasion, court directed the state of Assam, represented by the public prosecutor, to place the medical report of the appellant who is in custody. In the morning, Ms. P. Bhuiya, as a public prosecutor, placed the relevant materials about the report in original from the jail superintendent, because the medical report was furnished by the jail doctor. Now, in the second half, the counsel for the appellant placed a copy of the medical report of the appellant has been forwarded by the jail superintendent of Central Jail, Guwahati. Though there was no copy mark to the appellant, on being inquired, counsel for the appellant said that it is the family members of the appellant provided to him, and it has been placed before the court.
No, for the information, my lord. Just
The information has been provided by the family member, whatever it may be. Question of furnishing a copy of the jail doctor or the superintendent of Central Jail, Guwahati, to the appellant side doesn't arise, because direction was specifically to the public prosecutor to provide with this. We don't know how come the appellant could have the original copy along with the envelope, the name written to the public prosecutor. How come the appellant could have this particular letter? Tell us. It indicates something, and the concerned counsel is a senior advocate, mind that. It indicates something else. Unexpected thing. We don't it's open for us. There is nothing to hide. Camera is before us. How you conduct. There is no hide and secret game here. It's open for. Yes, Ms. Bhuiya, we are waiting for you. How come this envelope and the contents
Oh,
been made
no.
available?
That
Because
was
it
me.
was a-
That was my copy, my scene.
How come
Sir.
the petitioner, how come the counsel for the appellant could place it before the court?
But I have placed it, but just now.
You place it or he placed it?
no.
No,
They placed.
Our side it has been placed.
No, in the morning, Lordship,
You have given it to us.
so 2 copies I've given. That envelope was, I kept it, then
Acha.
sir asked me like, can you give the copy to me? Then I delivered to him and went to another court.
It is Mr. Das who gave it to us.
Okay.
I don't know
Counsel-
about
counsel-
subsequent
Counsel for the
communication.
appellant. Okay, fine.
তোমাৰ কবি এইটো personal কবি নেকি?
সেইটো মোক দিছিলে কালি।
কোৰ্টত নাইতো?
এড্ৰেছটো পাৰ কৰিছে মই চোৱা নাই কিন্তু। অ।
I'm sorry, my lord.
It's okay.
A situation has been created.
No, we thought it was given to us by the counsel for the appellant, because otherwise counsel for the appellant. The morning we have allowed Mr. Kamar to read it. Mr. Kamar had read it in the morning.
That was my copy, Your Lordship.
That was her copy, madam. I thought that, my lord, that copy is meant for the court.
Fine. Yes, Mr. Das, anything else to be, yes, Ms. Bhatt.
May I go?
Yes, yes.
Obliged.
Yes, Mr. Das, anything else to be added?
My lord,
Anything else to be added?
no.
Fine.
That's
You want to say something?
My lord, this is my submission.
We'll consider this medical report. Purva,
it.
we'll consider the medical report submitted by the jail superintendent.
No, this is a synopsis which we have created. Synopsis which we have created to provide before this honorable.
Mr. Das, when the charge was framed,
Mala.
when charge was framed,
Charges frame. It had it.
third February. Third February 2020.
Frame on 3/2/22. 3/2/22.
Mr. That's only one thing. What do you have to say with the finding of the coordinate bench of discord? Because earlier, as you have seen, the court, while rejecting the bail prayer of the appellant at para 91, 92, and 94.
Okay, so
Page number 168. Sorry, 162.
para 91.
91, 92. What do you have to say?
In the present case, we are on the prima facie view that the appellant does not appear to be hardcore under trial and is stood in marginal in the home blast of 15th. As as such, his bail can be considered even before completing 5 years of detention. If he has completed 4 years of detention, if there is no likelihood of trial being completed in near future. Well, that is a we have seen it. That is an observation made by but a particular, remember, see, there is material, I wouldn't say anything, because there is a judgment.
No, we are not in review, right? We are not in review, and this finding, that observation,
My
para
observation,
91.
there is that observation,
So what do you have to
because
say on this?
court, at a time, anyway, if we look into it, because two accused were there at a time, while deciding the matter, two accused, one court has granted bail. In this case, court refused to grant bail.
No, because he did not complete 4 years, which now has been extended to 5 years.
But the other accused also, it is not that completion of 4 years. That is from
Goswami,
From Goswami Magat.
Raskor,
That accused.
Raskor, Prakash Raskor, Raskorn,
Yes,
Prakash Raskorn.
he was granted bail because the same set of accused, they were arrested somewhere here. It's not that because Prakash Haskor has completed 4 years or so. His facts were okay.
There was only a mobile section for mobile dating, creation of nothing.
Maybe.
no cost difference.
And this has come only because of Najib's case, Malar. Najib case. This para 91 has come because of Najib case at that time. Para 91 and 92, if read together, you also will find the answer. Because my impression is that, Malar, there's a prima facie case against the present appellant. Court did not grant bail because there was a prima facie case and there is a restriction 43D5. Now, court wanted to grant bail had he completed 4 years at that time. K. Najib case would have been taken into account and he would have been granted bail. Not because of the materials.
Yes, do you have the bail order of Indra Mohan Bora?
Yes, ma'am. Yes, ma'am.
Give it to.
Yeah, thank you.
Mr. Jit Kamar, London Senior Counsel. You are Mr. D Nandi,
Yes, madam.
assisted by Mr. D Nandi, counsel appearing for the appellant slash accused. Also heard Mr. Dilip Das, London Senior Counsel. Standing Counsel, and I assisted by Mr. You are Mr. Bharadwaj. D. Bharadwaj, Learned Counsel for the restaurant number one. We have also heard MSP Bhuiya, Learned Senior Counsel, from Additional Public Prosecutor Assam for the respond number two. Pursuant to our order dated 16/7/2024, Ms. Bhuiya, Learned Additional Public Prosecutor for the state, placed the communication of the Jail Superintendent of Central Jail Guwahati furnishing the medical report of the accused appellant. Up to date. Medical. রাতিপুৱা দিছিলো যে, original. Order is up.
But I want to file an affidavit to bring the certain developments in this case, my lord. Maybe day after tomorrow.
My lord, we have some urgency in this case, since 2018, investigation has been stayed. And I am dying to do this case, So let it come up.
I'm also interested to complete the matter.
Maybe tomorrow, we will,
On the prayer of the council for the parties, list on 25th. Accommodated. Yes.
Hey, please, your lordship, I beg to mention item number 2. My lord, we need 4 weeks time to file our affidavit in reply.
Item number,
2. We need time to file our affidavit in reply. Your lordship, may kindly grant us 4 weeks time.
Lordship, I have come from Delhi in this matter. May I request a specific date?
give us,
Could it be,
you select it.
could it be
Okay,
20,
absolutely.
could it be 22nd of August, your
Okay,
lordship?
now, by which date you will be filing your affidavit?
Your lordship, we need 4 weeks time. We have
Why?
recently received the affidavit
We
in
filed it
opposition.
before the last date we filed it.
4 weeks for filing affidavit.
3 weeks,
cannot be
your
considered.
lordship.
That's why Mr. Chaudhary is laughing backside.
3 weeks, your lordship.
No, no.
We had filed the affidavit before the last date.
Has been agreed with the parties. The petitioner. You will file your reply.
Yes, lordship.
Shall file a reply to the affidavit of the respondent number 2. On or before. 12th of August. Furnishing a copy of the counsel for the respondents. Obtaining necessary. You want on 22nd?
22nd of.
Is it possible to have it on 28th, 20?
Could it be 23rd in that case?
23rd, 24th, 25th, 26th, a holiday here. So that is why 22nd, okay, 22nd.
Deeply obliged.
What's your budget?
Lord, item number 18.
Huh.
I think I appear for respondent number 2.
Okay.
And we have agreed, my lord, we will file application before the trial court. We'd like to compromise and withdraw the matter. So that will let the matter come after 4 weeks. In the meantime, we will file appropriate petition before the trial court.
We don't think so we'll able to reach
I'm-
today because of time.
Okay.
If the matter reaches, we'll definitely.
Miller. May please.
Ask someone to be here by the time.
There will be some.
May please, Your Lordship. With the consent of the other side, I beg to mention item number 34. In this case, senior counsel Mr. B. Datta is appearing. Due to some medical checkup, he had to leave the court. Can it be on 12/8, Your Lord?
These are all hearing matters. Don't
Yes.
have to make a mention, may not reach. If the matter reaches, we'll pass on.
Yeah, please.
My lordship.
Item number 28. It is criminal appeal. It has long been dragging. Early that,
Okay,
preferably in the first week of August.
Are you ready?
Yeah.
If you are ready, if time permits, we'll take your matter as a first item. Are you ready?
Yes.
Fine, wait for your turn. We are going to take it.
No, pardon you, pardon you. Not ready,
Okay, we'll pass order. Don't worry. We'll pass order. Let the matter reach. Yes, next.
May I please, Your Lordship? Lordship, I beg to mention item number 24. With the
Don't have to make a mention at this stage
At-
for hearing matters. We may not reach.
May I please? I beg to mention item number 4, Lordship. The Lordship engaged counsel is out of the station, Lordship. So matter may be adjourned for the day.
Okay, wait for your turn. We'll just see.
Okay, Lord. Much ob-
Lordship, I'm praying for listing of a criminal petition, Your Lordship. It was a 2023 matter. It came one. I have a stay, but I want to get it listed at any convenient date, Your Lordship.
What about the steps taken on the response?
Yes, Your Lord, it has completed.
Service is complete.
Yes, Your Lord.
It will come for admission.
Yes, Your Lordship.
July 31st.
31st of July. Lordship.
Please, your lordship. Lordship, service have complete.
Just. Wonderful. What's your good name?
Visit me.
For the petitioner. You are appearing for.
I'm for the sole respondent, my lord.
And Mr. Council. Service. It is completed. Service. Registry has also received the relevant record. It was called for by order. 2309. Registration list is matter for admission.
Obliged, my lord. May it please your lordship. So we are directed to take fresh step upon the respondent, lordship, second step, lordship. And the answer has been called for, lordship. It has been received, lordship.
Who is appearing in this matter?
Now, CBI, we have filed a petition challenging a order of the trial court, lordship. Wherein, lordship, we have filed a petition for custodial integration of the accused, lordship. He is behind the bar, lordship, now. So, respondent is the sole respondent, is the accused in this case. He's in jail, lordship. Notice has been served upon him, lordship. We have taken step, lordship, twice, lordship.
The opposite party is on bail.
No, lordship, he is behind the bar. He has been arrested, lordship, subsequently when he
Put strike here.
could strike. Summons were issued to him, lordship. He didn't appear, therefore NBW has been issued against him. And when he appeared, lordship, he was put behind the bar by the trial court, lordship. They filed by bail petition also before this honorable, that was rejected, lordship. As because he has threatened the witnesses during his custody in jail, lordship.
Because
Lordship.
Was the engaged counsel for the accused here?
No, Lordship.
No, he was represented by some counsels before the,
In bail application, Lordship, the file petition counsel was there. In this case, Lordship, as because notice has not been served, Lordship, there none appeared for the accused. Basically, Lordship, the fact was that, Lordship, in the year 2007, murder took place, an incident took place, Lordship, wherein, Lordship, the then ADGP, Lordship, was also an accused, along with others, Lordship. Initially, the state of Assam has submitted final report, Lordship. Thereafter, Lordship, the son of the accused, he filed a PI, Lordship, before this honorable court, and this honorable court has directed CBI to investigate. And Lordship, thereafter, CBI investigated the case and filed charge sheet against this accused person under section 302, Lordship, 364, and along with other IPC offenses. Lordship. That was the fact of the case.
earlier bail application was filed from the police quarter because they were a resident of probably the office quarters.
Earlier, bail application has been filed by the accused himself, Lordship.
That's true.
Accused,
The affidavit was owned by his son
oh, Lordship,
and address was given as his residential address as the quarter.
Lordship. So we have mentioned the address, but what is reflected in the charge sheet, Lordship?
True, that is the reason we are asking you, any idea of whether he is still continuing in the office quarter?
No, Lordship, no idea. Let us, Lordship, serve a notice in the jail, Lordship, to the
That
superintendent of
would
jail, as because he is still in jail, Lordship.
But his record doesn't have
Paragraph 7 of the petition, Lordship, we have stated, Lordship, his bail was rejected.
no, he was taken into custody because NBW was
NBW
issued
has
to him,
issued,
right?
Lordship.
During his production, what was the arrest? What is the address given? That's what we are looking for.
Lordship will get in the court record of
It
the
is not
trial.
in the charge sheet. That is the reason. The address you have given is in the as available in the charge sheet,
Charge sheet,
right?
Lordship, right, yes,
And it has written say there no such address.
Lordship. But Lordship, your Lordship will get it in the LCR. Lordship,
You are going to the LCR only.
if they have shown any affidavit in the bail application.
In the affidavit was shown by
Son
his
of the-
son
What?
and specifying the quarter number in which they is to reside. Will allow to take steps, but thing is this, have the proper address.
Let us take by dusty mode, Lordship, in the jail, Lordship. If the Lordship directs, Lordship, we'll take a fresh step by dusty mode, Lordship.
That notice issued, let us see. Because warrant was issued, no?
Yes, Lordship.
There will be proper address, that's what I've been looking for.
The copiers, 10 copies of the warrant was not available in the LCR, I think. Those documents are not relevant in this petition, Lordship.
Where is the office note? Dated 20/07/2024. Notice on the sole respondent. Public accused. Sole opposite. Return answer. Mr. M. Halil, Leonard, pending counsel CBI. Submitted that the sole respondent is presently in the central jail at Guwahati. As he was arrested in connection with the CR case or in the case of that earlier police case? Your NBWA, he did not appear before the.
He appeared before the trial court when someone was issued by the trial court. Summons were issued, he didn't appear, therefore NBW has been issued.
As the sole respondent did not appear before the court in spite of receipt of summons in CR case number 4381/2021. From the records of the case, it is said that the sole respondent trial court lecture sections case 230. On 06/06/2023. Prayed for bail before the Learned Sessions has come Metro Guwahati in Sessions case number 230/202, in which he gave his address as Pralipa, Port Media, or case to Media. Accident of village file number. That's 7810781019 district complement. In the said bill application, he was represented by his son, Nanmani Saikya, resident of quarter number 5, block CSB headquarters, Kailipur, Kamrup, Patna. In view of the petitioner hearing, the CBI is directed to take steps on the sole respondent. The appropriate to address it. As well as the superintendent of Central Jail, Kamrup, Patna. As well as the operator include the superintendent. On report. 25th of July. List of 28th of August.
Let it be earlier. Let it be on 8th of August.
Don't come.
6, 7,
That week it won't come.
19th of August.
Possible. We'll have it on 21st.
21st. Okay. Earlier.
Yeah, photos.
Earlier. Wait, please. ছাব্বিশে দিলেও 26 করে রাখি এটা তো 26 তো নামাইবে না এটা তো বাকি করব না
My lord, your lordship kindly, my lord, I am placing the miss case first, my lord. Your lordship kindly see the order dated 14/5/2024, my lord. I am, my lord, 438. 14/5/2024, my lord.
Just a minute. There are miss case.
Yes, my lord. Miss case, my lord, 438 for suspension of the sentence, my lord. Order dated 14/5/2024, my lord.
Mr. Mahanta,
My lord,
what we have a report of the process server
my lord.
and earlier registered post was issued. We'll
So,
just
my
let in-
lord, I am not on that. Actually, my lord, that is wrongly, my lord, wrongly, my lord, that complainant is a made party. In a statutory appeal is not required, my lord. It is not even required.
Matter of
but-
376, that's the reason.
No, not even 376 is not required, my lord. When there is a statutory appeal, except, my lord, POSCO and my lord, revision or against quashing, my lord. But your lordship kindly see order 14/5/2024, my lord. Heard Mr. P.K. His Lordship got it. 14/5/2024. Heard Mr. P.K. Dekar, learned counsel for the applicant. Also heard Mr. B. Shamal, learned additional public prosecutor Assam for the state of opposite party number 1. By this application under section 4389, the CRPC, the applicant have paid for a stay of the execution of the sentence by judgment and order dated 19/3/2024, passed by the London Additional Session Judge 1, Kasar Silson Session Case number 47 of 2021, convicting the appellate under section 376, 114, 342 IPC and sentenced to undergo RI for 8 years and pay fine of rupees 10,000 each and default RI for 6 months for the offense under section 376 and 314 IPC and to undergo RI for 6 months and pay over rupees 10,000, 1,000 each of the SI for another 1 month. Each of the offense under section 342 IPC. Payer for applicant will be payer of the applicant will be considered under receipt of the trial court record.
Yes, madam, have you gone through the record?
Record
Yes,
has been
sir.
received, my lord. So now, my lord, your
What is the
lordship
record?
kindly see, I am not the main accused, my lord. I am actually, my lord, at best, my lord, it is but 114 will come to me, my lord. There are 2 persons, my lord. Main accused is, my lord, main accused is Kanai Lal. I am not Kanai Lal. There are 3 accused convicted under section 374, 376, my lord. And your lordship kindly see, my lord, record has already available and I have also annexed the, my lord. Your lordship kindly take up the main appeal. In main appeal, my lord, I have annexed the, my lord, evidence of the, my lord, prosecutings as well as, my lord, IO and, my lord, medical. These are the 3, my lord, evidence is important for this case, my lord.
Just a minute. Please take yourself, go just glance it.
Oh, my lord. मुझे क्यों भूल बोली पहले फोटो तो कहाँ है अंदर कहाँ है वो ओरिजिनल इंश्योर था ना मैडम एक्चुअली मैं हियर कथा एपिडो कथा पीडब्ल्यू सिक्स को साले वाला हेक्टिंग मोड स्टेटमेंट আৰু मैंने किस तो নহয় না মেন তো কি বেলেগে কৈছে নেকি নাজানো কাটা itu কৰা নাই এপিলটো ৰেকৰ্ড দিয়া এটা আহিছে conviction is for 8 years madam originally initial I think I guess to take one na that's okay
Yes, anything you want to say? We have gone to the record. We have gone to the record. The statement of the victim, statement of the,
Yes, my lord.
also the concerned doctor who examined her and the date of the incident.
And Doctor, my lord, actually not concerned with us, my lord. Your lordship kindly see, my lord, PW1, page 16, my lord.
We have seen that.
But not a single, my lord, evidence against Mohesh, my lord. Number one.
That's fine.
Absolutely
There is
no.
nothing.
And against, my lord, Sanjay Gwala, my lord, your lordship kindly see IO. Evidence of IO, my lord. Very important, my lord. Page 48, my lord, my affidavit, my appeal, my lord. Evidence PW7, my lord. PW7 is the IO. And your lordship kindly see the cost part, my lord. What she stated in her evidence, my lord, that was not been stated before the IO, my lord. That is very regarding, my lord, Sanat. Against Kanailal, my lord, yes, constantly, my lord, she is against Kanailal.
Yes, what do you have to say?
Lordship, the 164 statement is corroborating with this statement of the PW1's victim statement, Lordship. And Lordship, the PW6 medical officer, Lordship.
Now,
Uh,
regard to the present two petitioners, the present appellant you're talking,
Yes, Lordship.
what do you have to say regarding the suspension of sentence imposed upon them?
Lordship, PW1 in his statement, she stated that, Lordship.
Did not state anything about the other accused, right?
uh,
Only the
she
one accused, the
mentioned
main
about,
accused and this
she mentioned about Sonat Gwala, Lordship.
Mention about Kanhailal.
Kanalal and Sonat Gwala, Lordship, that she
mention
also
about
tried
that.
to commit rape, Lordship.
But that was not meant by tell before the IO, my lord.
But the IO.
IO is very clear, my lord. Very, in IO evidence, my lord, PW1 did not say anything to it about Sonat, my lord. Page 51. PW1 did not state before me that Sanat Kumar Goala gagged her mouth and pinned her into the ground and she raised halla, but none came to Rajan Sancho.
Convicted accused slash appellants. By judgment in order dated 1903-2024, passed by learned Assistant Session Judge number 1, Kachar at lecture. In Sessions case number 47 of 2021. Arising out of Silsar Police Station case number 158 of 1518 of 2021. Convicted the present applicants under sections 376 114 convicted the present applicants and another, namely Kanhailal. Right. Kanhailal Kuala. KNAILAL. Under sections 376. The applicant under section 376 of the 114. 76 342 of the 114. And sentence him to undergo rigorous imprisonment for 8 years for the offense committed in the section 376 of the 114 IPC with fine of rupees 10,000, 10,000 each in default to pay in default rigorous imprisonment for another 6 months. And further sentence him to undergo simple imprisonment for 6 months for the offense under section 342 IPC with fine of rupees 1,000 each in default to undergo simple imprisonment for another 1 month, where the sentence against them to run concurrently. And they say such and such secure. But they say it improved judgment in order to such and another accused, namely Kanailal Gwala, was sentenced to rigorous imprisonment for 8 years with the offense under section 276 IPC. It is seen from the records of the case that both the applicants, along with the third accused, Kanailal Gwala, were taken into custody on last final 21/05/2021. And by order dated 23/07/2021, the London Session Judge Kachar Silchar released them on bail. After the improved judgment, the improved judgment of the 19/3/2024 by London Assistant Session Judge in Sessions case number 13.
Dismiss করে না অপমান ভালো
They are taken into custody.
My lord, I'll clarify one point, my lord. The date of judgment, that is judgment on 19/3/2024, he was put behind the bar because there is, my lord, but wrongly they filed the appeal before the session judgment. And that's my lord, after considering all these things, my lord, my lord, session judge also granted bail.
True.
But thereafter, my lord, they said, oh, there is appeal like to High Court, not the Session Court. Then it was cancelled, my lord.
True.
Again put on, my lord,
19/3/2024.
that bail was cancelled, my lord, and put behind the bar on 1/4.
Letter. The present applicants. Preferred in appeal. Proposal and assistant session judge. Number one, culture censor. Against the Seri judgment authority by committee. Wherein by order dated 28/03/2024. Additional session judge. Released, sorry, granted bail to the present applicants as they preferred appeal. However, on 30/03/2024, the learned assistant session judge number one, Kachar Silchar, recall the said order of bail dated 28/03/2024.
No, that was order recall on my lord 1-4,
It is not written 33.
my lord,
As per the record, it is.
page 77, my lord.
No, I don't know, but here it is at page, in the main record. It was recalled on 30/03. It was rejected by the at 5:30.
Yes, bail was cancelled, my lord. In view of the bail granted that I've convicted this earlier, is hereby cancelled.
Session judge on 30/03/2024.
And 1-4/2024, it was not
Considering the
maintained.
fact that appeal lies before the High Court, not before the Court of Learned Session Judge. Cancel the bail of the applicants. They rejected the bail. The order was cancelled. Thereafter, the present applicants prefer the bail. By this application, the applicants have prayed for suspension of the sentence. On perusal of the records of the case, more particularly, the victim of the case PW1, the
I. Hello, may I leave, my lord? I have another motion. Leave, please.
concerned doctor who examined the victim on the date of the incident, PW6, and the investigating officer of the case, PW7. He keeps up the political Silchar case number 1512. It is found that there is no such implication against the present applicants, though in her evidence the victim PW1 stated that the applicant number one tried to commit rape on her. And that. But
Lordship.
this is the second chance. We'll give him another, and we'll fix the case next week, and then we'll pass the appropriate order.
Lordship, I want to make a humble submission with your kind permission.
Yes.
If we look at the first order passed in the matter, it was stated that the matter of stay will be considered after getting hold of the trial court records. But on 21st of June, the stay was granted without looking at anything. Neither we were heard. We had asked for a legible copy of the petition that was only provided to us. And in the meantime, a stay was granted. A person who has forged documents in the Honorable High Court to get a bail, he has been charge sheeted, cognizance taken, summons issued. How can he be granted stay on the matter, sir?
You are Mr. Agarwal?
Yes, sir. Yes, Lordship. And this case has been pending and to enjoy the day and he wants to be off the court.
Mr. Agarwal, please hold on.
Thank you, sir.
LCR, we have not visible.
No representation on behalf of the petitioner. Your name for the responsible. Part. Prosecutor appearing. And Mr. Manish Kumar Agra, reference number 2 in part 2. Video conference. The petitioner obtained after obtaining stay order on 21/06/2024 from the relating the PRC number 878/2023 pending before the court of JMFC Kamrupatra Guwahati. We remain an unrepresented even on last update. Do the court observe that if the petitioner remains unrepresented in its last order, though the court can last order, observe if the petitioner remains unrepresented, the court consider to take the interim order even Australian cost. The interest of justice, the court intends to get one more opportunity. List on.
Lordship, can we have it on 29th if it's convenient to the Lordship? A humble prayer. 29th of July.
29th of July, there will also admission and all. There may not be, this matter may not reach. So that is why you have.
Okay, okay, Lordship. I'm highly obliged on 30th. 30th. Highly obliged.
May I please, Lordship, this application for washing and VW only, Lordship. On last occasion, Down to the record, the honorable directed to file additional affidavit for order dated 4th July 2024, which is passed by the additional district and session judge Kanpur Metro.
File your affidavit.
On Lordship, page 26. I have annexed the order dated 4th July. But in this order, nothing is against the petitioner, Lordship, as the case already filed on 9th April 2021 against the petitioner.
I know.
Yes, what will you do? We'll pass this order. He shall appear on 16/8. Only in temporary manner during this period, he will not be taken. He shall file appropriate application and the court shall consider it accordingly. You are Mr. Ahmed.
Yes, Lordship may be against the NBW.
Only till this period. You appear before the Learned Trial Court on 16th of August. Till then, you'll be getting benefit. Otherwise. Allowed.
Yeah, please, Lordship. Okay, where for service, Lordship?
The campaign is nice. Campaign is. More respondent number 2. Campaign is अपनी हॉट कंपनी में मान नहीं पता ये क्या नहीं पड़ी इंडियन रिपोर्ट कंप्लेंट अपनी में
Service report and respond number 3 and 4 are out. This is a reminder to the also can copy the records of complaint case number 4779 of 2019 to the Court of Learned Chief Judicial Magistrate Kamrul Metro. List on. Twelfth of August.
Lordship, steps have been taken, Lordship, but service not completed.
You have not taken steps, it appears. Where is the office note? Dated 19/07/2024. Pursuant to the order dated 25/06/2024. Petitioner is yet to take steps on the respondent number 2. Petitioner shall take steps on the respondent number 2 by registered post secretary. 26/07/2024. Further time is granted. Further time is granted. The petitioner to steps on the respondent by the on or before 27. It's a reminder. The Yes, you can work the case there.
Lordship.
That will be better.
CD will be required, Lordship, because crossing my appearance.
Hmm?
CD will be required, Lordship, in this
No,
case.
that is why we can bring it.
Lordship.
List on 28th of August. Okay, sir. The stated Mr. Such and such, an additional public prosecutor. Pursuant to the order dated 25/06/2024, shall place the relevant case diary of non-Guwahati PS case number 42/2021. Copy of this order.
Obliged. 28.
Let me know, Lordship. Madam, the government has filed an IA, madam. Lordship will take the IA first, madam.
Where is the order?
Madam, order is at page 33, madam, of the IA.
Last piece of this I will.
No, more, IA, more.
Yes, but we have to.
Madam, no. But after this, madam, after passing this order, madam, on 31st August 2023, the government has filed an appeal, writ appeal, madam.
Hmm?
The government has filed an writ appeal.
That we have seen that order.
Madam, against that order, madam. That is your case number, madam, 36, madam. And the honorable division bench was pleased to return the case before this. Agbuta case before the single bench, madam.
Why 226 you have filed? You are hard on that day. If the order is exported, then only 226 will come.
Madam. No, what happened, my lord, in the filing section, if we do not write any act or section, my lord, they do not
That's not the way.
accept the same, my lord.
Why this IA? The IA is
Yes.
mentioning, will you file your affidavit because of
Madam, the main issue is that Lordship has directed to pay the pension, madam. But madam, we are bound by the
see, basically the read petitioner filed the petition, right?
madam.
And she prayed for the direction.
Madam.
Of the court to release her pensionary benefit.
Yes, madam. That was the prayer, madam.
Now, that prayer
But that we have done, my lord. We have given, my lord.
Right. That prayer was on the basis of the order. She was a party in a proceeding. Do you have the copy of the writ petition?
Yes, I have, my lord.
Page number 23.
23.
When did he expire?
Now, he expired on, my lord, 3/7/2019.
3/7/2019.
And he joined on
Now-
22/1/2019. So, my lord, he expired before 1 year, my lord. The OM says, my lord, that he have to complete at least 1 year, my lord.
That is the reason
That is the reason, my lord. That is the only reason.
pension cannot be given.
My lord. That is the
Now
reason.
there is a scheme.
There is a scheme, my lord.
For what?
Yes, sir. There is a scheme, my lord.
There is a scheme if somebody expires,
Now that scheme is at page
died
22,
in
my lord.
harness. Then what happens?
But this is in lieu of the compensatory appointment, madam. This was published in lieu of the compensatory appointment.
That's right.
And this, as per this OM, madam, at madam, page 22 of the IA, madam, it specifically says that the person has to work for at least 1 year, madam. And there was not no fault of us, madam. But unless and until the PVR police verification reports comes, my appointment letter cannot be issued.
Page 22.
Madam, page 22, madam. That
Which
starts,
clause, Mr. Da?
this starts from page 21.
Page 21.
Madam.
Yes.
The office memorandum revised comprehensive guidelines for family pension in respect of government servant who died while in service pursuant to the compensatory family pension scheme 2017. Now, madam, if the lordship comes to the next page,
No, this page lordship clearly indicated that lordship, I am entitled to get such benefit lordship. Please.
One by
Yes,
where is it?
yes. Yes. Below 7 years entitled to get at least 30% of it. One, two, Romani. That's possible.
7 years will continue. 7 years.
Whoever is less, their family pension will be reduced to 30% of last basic pay down in case where government servant had less than 7 years of continuous service. Even if he entered at for the period of 1 day's lordship, he is entitled to get pension or benefit lordship, 30% lordship, reduced to 100% to 30%. Less than 7 years lordship, maybe lordship for the, if rendered for the day lordship, entitled to get pension or benefit lordship. Subsequently, if his service has been regularized. The notification itself is lordship.
And this is different, madam. This is really good.
Mr. Das,
My lord.
come to page number 22. Read your
20?
first paragraph,
Not 21, my lord.
page number 22.
22. Yes, my lord.
Or you can read para 3 in between, the compassionate family pension.
My lord.
Read para 3.
My lord. There are three. The number A, the government in finance department by notification number so and so has come up with the schedule of compassionate family pension in lieu of compassionate appointment, for which there has been some changes in the admissibility of the family pension to the family of the legal heirs of the deceased government servants died in harness on or after 1/4/2017.
In the case in hand,
My
the
lord.
person expired in 2019.
Yes, madam. Madam, dear after madam, what is the next paragraph? Is continuing, madam. As per the provision of the state scheme, where the employee dies before superannuation after completing minimum 1 year. Madam, this
Please
we
go
have
ahead.
stuck, my lord.
Please go ahead.
We have stuck on this one, my lord.
Please go
Minimum 1 year of continuous service or the family pension equal to 100% of the last pay drawn by the deceased employee be paid to the family holding legal heirs who have the eligibility to receive the normal family pension as per so and so for a period up to the date of deemed superannuation of the deceased employee. That is the date on which the employee would have superannuated had he been alive.
Hmm.
My lord. The last pay drawn for this purpose is the last basic pay, pay in the PD plus GP. Over and above the compensation family pension will get the applicable DNS relief and other relief amount as admissible in normal family pension. This will also be revised periodically as and when normal pension, family pension are received.
Revised.
Sorry, revised.
Come to page number 23.
Madam.
The fourth paragraph. However,
However, the government servant appointed under a new defined contributory pension scheme and dies on or after 1/4/2017 shall be governed provisionally by the provisions as described under clause so and so of these guidelines and in terms of para 5.9 of the so and so, read it so and so. Madam.
One, T, Romani.
heard Mr. SP Das, learned counsel for the applicant. And Mr. M. Thakia, learned counsel for the opposite party. For proper adjudication of this case. Commissioner Secretary Finance. Department of the State. The incorporated. As party respondent number 4. Mr. Any government advocate is there, you are appearing for whom?
Respondent two lot. Party the
And for AG, my lord.
AG.
Any government advocate here? Getting government, I'm surprised. Take it on number. You are appearing for AG? No, B2. And it was accordingly. Registry accordingly to the need. It's a notice. Today. Opposite party. The applicants are filed. Now representative. List on. Sixth of August.
Till then, lordship, at least 30% lordship.
On that day,
pension
we'll
and
first. Let the finance department be.
Yes,
Yes,
that will be.
highly open.
Yes.
Lordship, item number 27, there's an interim order, Lordship, it may continue.
You want to, wherever there is an interim order, with to him, will consider. Where there is interim order.
Lordship, I took item number 25 as an urgent matter, my lordship, on 30 July. Lordship, item number 29. The petitioners are behind the bar for last 2 years, Lordship. If date may be fixed, Lordship. In this month.
Okay, 29 and 30, both on 6th of August.
6th of August. Deeply obliged.
Lordship, item number
My lord,
23.
item number 28, that may be lingering for 2 years more.
Interim, sir. When interim.
I am for the respondent number 1. Is an appeal against acquittal, my lord.
If there are any stay orders, you give the numbers to our bench and we'll do the need.
Lordship, item number 23.
Okay.